Hi, I'm Catherine Ballantyne, a partner at Madgwicks Lawyers. Today's case update relates to a case in the Victorian Supreme Court and involves injunctions and franchises, something which we at Madgwicks have a lot of experience in. The case is Lanhigh Proprietary Limited and 7-Eleven Stores Proprietary Limited, 2021 VSC 587. This case essentially is a case where 7-Eleven leased a property, a store in Heathmont. The lease had a term of 10 years with an option of another 5 years. Ms. Lee and Mr. Wang, we'll call the plaintiffs that, they're the directors of the plaintiff and the franchisee, entered into a franchise with 7-Eleven to run that store. And essentially 7-Eleven was going to license out that store to them. What happened at the expiry of the 10-year lease, was that 7-Eleven did not take up the option for another 5 years of the lease. That essentially meant the franchise agreement with Ms. Lee and Mr. Wang was then terminated, because the store was no more and the franchise was to run a 7-Eleven store at that premises in Heathmont. Ms. Lee and Mr. Wang were obviously quite upset, and they said it had been misrepresented to them that the franchise agreement had a 10-year term, and they were not informed that the franchise agreement's 10-year term would expire if 7-Eleven did not exercise the option. For the further 5 years. They thought they had the full 15 years. And they also said that the 7-Eleven's failure and decision to exercise the option on the lease for the further 5 years was unconscionable under the Australian consumer law and not in good faith. They said, look, if this happens, if our agreement is terminated, we lose our business, we have to terminate our employees, we'll lose the opportunity to re-establish our business, we lose customers, and it's going to be devastating for them. So they went off and asked the court for an injunction to prevent 7-Eleven from terminating the franchise agreement. The court agreed to the injunction because they said there was a serious issue to be tried. The continuation of the business kept up the status quo. So in the balance of convenience, it was the best option for everyone. Mr. Lee and Mr. Wang's, Ms. Lee, sorry, and Mr. Wang's business would come to an end if the injunction wasn't allowed. And this was likely to have serious consequences for them beyond just the financial, because for an injunction, one of the factors the court looks at is damages and adequate remedy. Will damages do the job after the event? And in this case, the court said, no, it's not going to be sufficient. Damages is not sufficient. One of the other factors they looked at was that Ms. Lee and Mr. Wang, or certainly at least the plaintiff company, had given an undertaking to pay damages suffered by 7-Eleven if ultimately they were not successful in their claims. If ultimately Ms. Lee and Mr. Wang were not successful in their claims against 7-Eleven, any damages 7-Eleven suffered because of the injunction, Ms. Lee and Mr. Wang would pay. And with every injunction, there's always an undertaking as to damages, and that's something that when you're looking to bring an application for an injunction, you need to seriously think about what is the downside. So the lesson in this is that injunctions are available. They are available when the harm hasn't actually happened, but it's threatened to happen. But you need to be very careful when you do apply for an injunction. It's a highly technical area and you do need legal advice, and you need to carefully think about it and think about the undertaking as to damages as well. And the last point really to take out of it is an injunction isn't usually an end as to itself. There has to usually be an underlying case which has to be heard. So the injunction will usually preserve the status quo until the final case is heard. So you want to be pretty sure that your final case is a good case and has reasonable prospects of success. I hope that was helpful. Thank you.